Good afternoon. Welcome. My name is Michael Cosentino. I'm an attorney at Wilshins, Cosentino & Nobbins. I practice in the areas of financial services litigation, and I look forward to introducing my fellow panel members who will participate today. Will?
Hi, my name is Will Haddad. I'm a partner at Pasquarello Fink Haddad. I have a similar practice in that I do financial services litigation. I also provide compliance services to investment advisors and broker-dealers.
Jeff?
Hi, this is Jeff Millsom. I'm a lawyer at Adler, Pollock & Sheehan. My practice is exclusively litigation, and most of it is in the banking and financial services arena.
And our leader for this seminar, Bob?
Thanks, Michael. Rob Fisher. I'm a partner at Nixon Peabody in Boston. I'm in the Government Investigations White Collar Defense Group. I'm a former federal prosecutor and was also senior litigation counsel at FINRA prior to joining Nixon.
Now, Rob, since you are the attorney for the claimant in this issue, I'd like you to start off and take us through the background that led to this decision.
Sure, no, I'd be happy to. And I was the lead attorney on this for Mr. Feidelberg. I had wonderful help from an associate at Nixon Peabody, Scott Seitz, who has been working with me since our U.S. attorney days. So Mr. Feidelberg had been a longtime client of, when actually we can go to the next page, the background section of the slides. There we go. Mr. Feidelberg had been a long time client of Nixon Peabody, although I was not familiar with him until he realized that he had been barred from FINRA, which I'll always remember getting a call from him. He was passed through another partner at the firm who he had called that partner and said, I just realized I'd been barred from FINRA, which of course was complicating his ability to get back to work after a long illness. But just to provide some background before we go through his quest to regain his status within FINRA. Brendan Feidelberg, I'm probably going to refer to him as Brendan since I know him pretty well now. He was a broker dealer at a shop up in Danvers, Massachusetts for about a year and a half. Was going through a difficult time in his life back in 2018. And there was a federal and a state tax lien that was brought against him. He worked out, he hired counsel, not Nixon Peabody, but another practitioner to help him deal with this tax issue. He did work out a payment plan with the Commonwealth of Massachusetts and was working on a plan with the federal government. He did report the lien status to his employer. However, he had only told them about the federal tax lien. And the explanation for that is he thought the state tax lien, because he had a payment plan worked out, wouldn't be reportable. Of course, his employer disagreed with that decision. They took action to terminate him. And as I'm sure folks on this, folks in the panel know, and I'm sure folks that are watching this understand that under FINRA rules, the broker-dealer has to file what's called a U5, which explains why they terminated the broker. So that was filed on Brendan in April of 2018. FINRA, obviously reading that U5, then sent out what's called a Rule 8210 information request to Brendan. And they sent that via mail, certified receipt, signature required, and just regular postal. They received back from he was living in Newbury Street at the time. They received the certified mail back as not claimed. However, the other piece of mail did not come back. And shortly thereafter, Brendan did reach out to FINRA and had a conversation with the investigator for FINRA about the issue he had with his employer that triggered the U5. This may be the best time to talk about what a Rule 8210 is. I can briefly, we'll state a Rule 8210 is the rule under which FINRA is allowed to get information from members of FINRA. I compare it to, based on my federal background, almost like a subpoena. If you're a member of FINRA and you get an 8210, you have to reply to it. You have to send that information for FINRA. If not, it can have grave consequences, as we'll speak about later. But if anybody else here on the panel, Will or Michael or Jeff, want to jump in and describe any experience they've had with 8210, and then I can describe the process as it affected Brendan after that.
Well, Will, I don't know about you, but I feel that, you know, the 8210 requests, unlike, you know, the rules of civil procedure where you can object to, you know, a series of, you know, whatever ones you think are improper, the fighting back and forth on 8210s are very time consuming, and you usually do not prevail. They usually want everything in the kitchen sink.
Yeah, that's been my experience as well. You know, it's sort of this almost an echo chamber where there's no judge or somebody, you know, there's no protective orders, there's no real limitations on what they can request in terms of documents. And then as to testimony, there's sort of unwritten rules of the road where at what would be the equivalent of a deposition, your ability to interject and to make objections is much more limited than a conventional deposition in civil procedure. So it's a kind of very favorable to the regulator, and there's not a lot of protection for the registered person who you represent. That said, the preparation is similar in many ways, going through documents, going through the recollection and preparing to answer the question and just the question and so on and so forth. So there are some parallels, but it's a much more stilted procedure.
Right. Now, Rob, there was no OTR on the record of Brendan, correct?
Correct. No, there wasn't. So what happened? He received the Rule 8210. He acknowledged it. He had a conversation and an email back and forth with the examiner. And frankly, you know, sometimes the 8210s can be rather broad. I'm sure we've all seen 8210s that ask for everything in the kitchen sink. Frankly, this one was fairly narrow. They were focused on, we want all information regarding the federal tax lien, the state tax lien, any other reportable events we should know about since you've been terminated. You know, that was essentially it. Brendan did reach out. They granted him a 2-week extension. He was not able to gather the documentation he felt was required under the 8210. He reached out to them again and said, I'm running behind. I'm trying to get this paperwork together. Can I have another extension? They did agree. They gave him another extension, another couple of weeks. Now we're into the summer of 2018. And unfortunately for Brendan, he fell seriously ill with something that required extensive surgery and quite a long stay in the hospital, according to what he tells me. And we were able to put in the record, he almost died in the late summer going into the fall of 2018. And that required a long period of recuperation at one of his family members' homes. So unfortunately, for a long period of time, for many months, he was not at his Newberry Street address. So as you see here in the background, he was not able to respond to FINRA. He didn't email them anymore. And of course, they sent voluminous amounts of mail to reiterate the 8210 request. But then also, once you ignore the 8210 for a sufficient period of time, they will initiate an expedited Rule 9552 proceeding, which really allows them, you know, typically when I worked at FINRA Enforcement as senior litigation counsel there, what would happen is the examiners and staff would build a case. I would compare them to the typical investigators you would see. You know, if you're dealing with DOJ, they'd be similar to the FBI agents, right? They build the case, they gather the evidence, they then bring it to an enforcement attorney who will draft a complaint and then bring it to the Office of Hearing Officers and file a formal complaint. The problem with that is that does take a while. That can take weeks, if not months, before you're able to refine that package, gather your evidence, speak to any victims if there are any, draft up the complaint documents, and then get it filed with OVO. And by that point, you have attorneys involved, not only the enforcement attorneys, but people from the litigation counsel's office at FINRA. So it takes time. So the reason you have the expedited Rule 9552 proceeding, one of the reasons is that if you have somebody who is totally ignoring FINRA and there's these requests for information that they need, they can trigger this this hearing where if you don't respond, you're eventually barred, unfortunately, for life. And that's, we'll get to that, that's eventually what happened to Brendan. However, they were sending a lot of mail to his Newbury Street address, and it was return receipt requested. It was coming back as undeliverable. Even the some of the regular U.S. mail, I believe, was coming back because his mailbox was full. So he was clearly not getting the mailings from FINRA. But of course, at that point, once the 9552 is initiated, you have a short period of time to either respond to the 8210 or to request a hearing pursuant to 9552. And he was never able to do that because he was hospitalized and then recuperating up on the North Shore for a period of, I think, five to 6 months. So I don't know if anybody else has experience with 9552, if they want to jump in, but that's what eventually was triggered for Brendan.
Rob, did they change their methods of notification from when they went from 8210 to 9552?
No, it was really the same, Michael. They send the certified return receipt mail. They send the regular U.S. mail. Frankly, I was a bit surprised there wasn't more email communication. He had called them, he had spoken to them. They did have his email address, so there was another way to reach out to them. Brendan had no memory of them trying to communicate with him that way, and I didn't see any evidence in the FINRA filings that they had said, hey, not only did we send certified mail, we also emailed him 25 times. We saw no evidence of that. And again, this is a bit, I think the circumstance here is a bit unusual because Brendan did initially respond to the 8210, I think, and we'll speak about some of these other cases later, I think, but typically what you see is a broker dealer or a member just totally ignore the 8210. Even from the first letter, they just don't respond to it. And oftentimes the reason for that is because something grievous happened, right? They were terminated, and it may have been because there was an issue with, they have a victim complaining about something that was sold to them, or there's money missing, or there's an SEC investigation, or a DOJ fraud investigation. So, I learned pretty early on when I started at FINRA that it is quite common if there is an SEC investigation or a DOJ investigation or some other investigation where the member is looking at exposure to jail time or some other, huge fines and penalties that may be more important to them than their FINRA license, they may just ignore FINRA. Because like you said earlier, Michael, one thing that FINRA has the ability to do under Rule 8210 is trigger what's called an OTR, and on the record. And they will request, obviously, they'll usually start with asking for documents and data and evidence. And once they have that, it's not unusual to reach out to the member and say, hey, can you come in here? We have some questions for you based upon what you produced. And that's on the record. That there'll be a court reporter there. Sometimes these folks come in without counsel, and that can lead to real jeopardy. So, that's, I think, where what may have happened to Brendan if he had responded initially. And sent documents in, they probably would have then rolled on to an OTR. And that's typically what you see. I'm not sure if at this point anybody wants to jump in with their experience with an OTR, because I think that if Brendan did supply the paperwork and didn't fall ill, I think he probably would have been subjected to an OTR, which we eventually never had after it was remanded from the SEC.
Well, I think Will alluded to it earlier. I think the role of an attorney in an OTR is important. Under the rules, the attorney is permitted to sit there and listen and follow the line of questioning. But having done a number of these, and I know Will has, and Rob has, an attorney does anything but sit there and listen. He's there to advocate for his client, and the FINRA attorney will object, sometimes vociferously, but you need to protect your client and to essentially point out the seriousness of the OTR and what they're trying to do, and to offer your client any protections that you deem are necessary during that OTR. Will?
Yeah, I agree. There's definitely a role for advocacy even in that context. I think we should get a little bit into who conducts the OTR too. Typically, at least historically, and Bob, you can tell me if I'm wrong, it was investigative staff with an attorney present as well. I've actually seen a trend more so toward having just the enforcement attorney do it by him or herself, because that collapses that bifurcation you were talking about, where the enforcement attorney gets a completed file and doesn't know the case at the end before filing a complaint. I'm seeing more and more so that the enforcement attorneys, maybe with staff and with investigative folks, are at the OTR, taking a lead in the questioning, because they have to prepare a case, the elements of the offense, what's the evidence, ask the questions, frankly, in a more concise fashion. Often you get, and this is the grounds to object, Michael, which is massively compound questions from investigative staff, where you in truth don't understand, don't know what the question being posed is. It's just designed to get some kind of admission, or designed to get the your client to make an admission or ramble. And so there's some opportunity certainly to push back on that kind of questioning. But I think, and Bob, you can tell me if I'm wrong, perhaps recognizing that enforcement attorneys are seeking to be present more and more often and take a lead.
Yeah, no, I agree, and that's what I saw when I joined FINRA. And I, coming from the U.S. Attorney's Office, I compared it to almost like the grand jury, right? You do have enforcement attorneys there now who, you're right, the staff and the auditors, the investigators, they gather the information, they bring it to the enforcement attorney, and then the enforcement attorney will reach out to the member, which of course that's actually more powerful than what you could typically do in the grand jury, because you don't usually subpoena in the target of your investigation. But under FINRA rules, they're able to do that. They can bring the actual target in and ask them questions about what the investigators have found. And I know we've flipped to the next page of the PowerPoint here, and that's what we're discussing. The Rule 8210 requires members to respond and requires them to sit for this on-the-record interview. And frankly, when I started at FINRA, I was very surprised at how many members show up for their on the record without a lawyer. And I agree with Michael and Will. There is limited role for the lawyer. However, I think it is very important to have a lawyer there, because you're right, Will. As we all know, attorneys will ask very compound questions or very leading questions, and sometimes clients will give answers to questions they think that was asked and actually wasn't asked, and they're answering something else which only you would understand because you prepped that client. And frankly, you may have found other documents that would be helpful. So I think that there is an important role for the attorney to play. And frankly, my experience is that when a member shows up and they're the target of an investigation, I think people will sometimes act just more professionally when there's a lawyer representing you, and they'll be on their best behavior and maybe not push the envelope to areas that they may not be as confident in if there's somebody representing the target, so to speak, of the investigation.
Jeff, what are your thoughts on this? Are you letting this financial advisor go into this naked?
No way. No way. You gotta go in, and I think that's you said it, Michael. It's your obligation as an attorney representing the advisor to be there, to protect them, to do what you can, and you take the bullets for him if the enforcement attorney gets upset and objects. But that's your role, and that's what you it's what you earn your paycheck for. So I absolutely agree with all of you. An attorney should be there and should do everything in their power to protect their client.
Now, there is a line, Rob, that we'll get into in how strenuous you should be advocating for your client during these proceedings, and a means to an end. What's the goal here? What are you trying to do on behalf of your client? And we all have our own opinions of these types of proceedings before FINRA, and the power that they have. And I guess the question is, how much is too much advocating on behalf of your client?
Yeah, I think it's more of an art than a science. And as litigators, we deal with that a lot, whether it's in front of FINRA, whether it's a deposition in a civil suit, whether it's bringing someone to, the U.S. Attorney's Office for a proffer where they're questioned by agents. You have to know, when to punch back and when maybe to hold your fire. And as we go on, I explained to you how I reached out to FINRA in this instance. While it was not an OTR, there was, of course, back and forth negotiation with me on behalf of Brendan prior to our appeal for the SEC. And you're kind of walking a tightrope. You don't want to be overly aggressive because they hold all the cards. On the other hand, you do want to be able to advocate for your client and try to convince the regulator to maybe do the right thing before you have to go to the SEC. So, yeah, I think if you're in an OTR and there's a compound question asked, you can object. I don't think you want to be pounding the table, because at the end of the day, they hold all the cards, right? They get to sit for that OTR. This is going to be truly on the record. There's a court reporter there. This is something that may be reviewed by OHO someday, by the Office of Hearing Officers during a hearing. They're going to potentially have access to these materials. So I think you want to guard against looking too aggressive, like you're trying to hide something, but also advocating for your client and making sure they understand the questions they're asking. And again, and that leads me to the third point on here. If you don't respond, you're going to be barred. And while that does seem, when I first learned that when I joined FINRA, I thought that was very draconian. I said, well, somebody just forget. What if they forget to respond? That seems pretty harsh to then bar them for life. And in my mind, I thought, I'm a member of the board of Bar Overseers. We pay our dues as lawyers every year. I'm sure there's people that don't update their address and forget to pay, and maybe are suspended for a time, but that doesn't mean you're barred for life from being a practicing attorney. But I understand why they do it now, is because, frankly, I think more often than not, these 8210 requests that are ignored, like I said before, by people that have much more serious issues hanging over their head. And they've decided, I'm not opening my FINRA mail. That is the least of my worries right now. And I'll take whatever penalties they mete out and I'll deal with it later, either knowing or not knowing that means a permanent lifetime bar, which will kick in if they're non-responsive, usually after about 60 days after the 9552 notice. And unfortunately for Brendan, because of how long he was hospitalized and then convalescing, he blew through that 60 days also without ever opening his mail.
But let's talk about briefly these expedited hearings. Who are the hearings before?
Well, I think typically they don't have many of these hearings. That was my experience when I was there. So you file for the expedited hearing before OHO, before the Office of Hearing Officers, and if the person replies in that window, they can ask for a hearing. But oftentimes what happens, no one ever raises their hand because they're willfully ignoring FINRA. However, I find if you reach out during that window, so I think what would have happened for me, if Brendan had hired me during that window, I could have reached out and said, hey, this is what happened. He had a serious medical issue. He was hospitalized. He had to have surgery. We apologize for not responding to the 8210, but here is that information now. And here is the information supporting the reason why he didn't appear or didn't respond. And because there hasn't been a final judgment yet, they're able to sort of unring that bell, right? And maybe the penalty would have been, okay, let's do an OTR potentially and take his testimony and see what he says. Or would he be willing to take, a 6-month suspension and pay a fine? I think you then have the ability to work something out. Unfortunately, once you get to the point where you didn't respond and you blow through that 60 days, they fall back on that. You did not exhaust your administrative remedy. So before that's before that is not exhausted, you do have the ability to have a hearing before OHO. But frankly, in my experience, that doesn't happen often because you usually try to work something out.
Which you tried to do in this case.
Well, we can go to the next slide. Okay, so like just to recap, the 8210 and 9552, it is very harsh. You don't want to ignore FINRA. But I want to wait till we get to the SEC portion of this. So what happens, just to get it back to Brendan, he tries to go back to work at another broker dealer in February. He's applying for that new job. And what happens, he realizes he's been barred. So he reaches out to Nixon Peabody, who had done work for him and his family previously. The client relationship partner reached out to me because he knew I had worked at FINRA. And I had Brendan in for a meeting. And he explained to me what happened, that he had this 8210 request. He was in the process of gathering the information about the liens, and then he had this life-altering medical event. So at that point, I had a strategic decision to make. On the very day he hired me, I could have reached out to FINRA and said, hey, I now represent Brendan. I understand he's been barred. What can we do? But before doing that, I decided not to go down that path. What I did is I spent a bit more time with Brendan to make sure I had a complete file of what he needed to supply to FINRA for the 8210 request, because what I didn't want to do was reach out and then be back on the clock for the 8210 if Brendan hadn't given me everything we needed for the 8210. So that's a practice tip, that if something like this comes your way, always be cognizant of, once you reach out to FINRA, you're now going to be on the clock. And if you read some of the filings here, FINRA does not hesitate to communicate to the SEC and put in their brief for the record when I reached out to them. They'll put in there, got an email from his counsel, Rob Fisher, said he was representing him. It was 3 days before Fisher supplied the 8210 information. So be very cognizant of that before you reach out to FINRA or any regulator when you're in this circumstance, and make sure you have your ducks in a row. Now, there's risk to that also, right? If that one, but by this point, we're already months behind where we should have been. So you have to put pressure on your client. I need this information so we can get back before FINRA. And there was a little bit of lag time. We wanted to make sure that we had everything we needed, that we had documented not only the 8210 lien problem, but also that we could confirm and corroborate that he did in fact have medical issues and what time period they consumed of his life. And of course, then discuss the actual notice provisions. There was work we had to do with him before I reached out to FINRA. But I did, Michael, I reached out to them and said, I represent him. This is what happened. I have the information now, and I sent it to them. And frankly, I was hoping that the investigator would say, thank you for the lien information. We understand it was potentially a miscommunication between your client and his employer, that he did in fact tell them about the federal lien, but didn't disclose the state lien because he thought that was in fact not a lien anymore. And we will look at his medical information. And frankly, I would have been even willing to discuss with my client to go in for an OTR. I understand I'm producing documentation. Brendan, we may have to go in. You're going to be on the record with a court reporter, and let's explain what happened. And frankly, I think if they had gone that path and maybe recommended some other alternative to us other than a lifetime bar, they probably could have gotten it. At that point, they have the upper hand. What's our choice? To then go through a lengthy, costly appeal to the SEC, which frankly, at that stage, if I was betting, I thought maybe we would have lost, because the odds are against you once you have that lifetime bar before the SEC. So that's what I decided to do at that stage. I don't know, Michael, if you want to kick it out to the panel, if they have ever been in a position like that with a regulator like FINRA.
Jeff, Will, either one of you?
I don't recall an analogous circumstance, to be candid.
Will?
Yeah, the tactical decisions you're making, I think I've had to make, but never in such extreme circumstances where so much time has gone by and you're so delinquent, or your client is so delinquent in getting back to them. Typically, yes. I mean, if you can negotiate, if you get hired a little bit midstream, a little late into the process, yeah, try to, say, trade in some goodwill. I've just been retained, here's some information, and can we work something out, or at least have a conversation about an OTR, for sure. But this is so far down the path. I can't say I've had this a situation like this.
So I've had this once, and I actually took a opposite approach. I didn't feel that the conduct by the financial advisor was so egregious that warranted such a hard press by FINRA, that I said, I challenged them. I said, let's go for it. Let's go. Let's see what you have. Let's see how this financial advisor not responding, and in my case, the financial advisor had good reason, how that warrants a bar, and let's go through the process. And they backed off a little bit, which was helpful. And it lengthened the time it took to resolve the issue. But I just challenged them, and it depends on what level of person you're dealing with, and what backing they have, and whether they want to go forward or not. But I want to go back. I take it he tried to register, and it was on his CRD that he was barred, right?
Correct.
Is that what it was? Right.
Yeah, he checked his CRD. Obviously, he after his period of convalescence, he got back in the saddle. Actually, what happened is, if my memory is correct, his father had checked for him, and because he remembered the issue that Brendan had. He checked, and that's how Brendan found out, and then he called us immediately. So.
Right. So I just want to touch on a tangential issue, and when you represent either financial advisors or customers before FINRA, I mean, you're looking at the financial advisor's broker check. You're looking at prior complaints, prior instances, and the internet, of course, has come a long way, and investors are much more knowledgeable than they used to be, and have much more resources at their disposal to review a broker and see if there's any questionable conduct. And Jeff, you've come across this, right? I mean, if you have these complaints that are against a financial advisor, I mean, and you go into one of these hearings, how do you use that, or what shadow do you find that casts?
Well, it's huge. It's huge. It's you love to do it in the civil litigation context with a criminal conviction, and you never can. Well, that's not true in a FINRA dispute resolution proceeding, because if the broker has had a past indiscretion, either through enforcement action where the FINRA has made a finding or levied some sort of sanction against him, or if another customer has sued and alleged that the broker either misrepresented something or put them in investments that weren't suitable for that investor, that shows up. And we should probably back up. This broker check you're talking about is basically an online portal run by FINRA that anybody, any member of the public, can type in a broker's name and find out basically their rap sheet every time. Not only every time that there has been a finding against them by either an enforcement, by FINRA enforcement, or a finding against them in arbitration, a case brought by a customer. But even when there are allegations, the broker dealers that employ these brokers are obligated to report to FINRA, and FINRA puts it on broker check anytime the broker is accused, even wrongfully, of a customer violation or a any misdeed. And it's really useful when you're representing a customer and this broker has a couple black marks on his record, and the brokers know it. One of the things that's really come on in the last 10, 15 years is these brokers bringing actions in FINRA to clean their record, seeking expungement. We see, I do a lot of work in the FINRA dispute resolution context representing employers who are sued by the brokers, because any employment dispute between a broker and his employer has to be brought in FINRA. And I'd say, looking at the decisions reported each week or two, probably 80% of all cases brought are by brokers seeking expungement, so seeking to have their record cleaned.
Will?
Yeah,
What's your-
and I'm just typing a note to Steve here, who wasn't on that, to see if he can pull up on the internet broker check for those folks who are not familiar with it on the panel. Steve, I don't know if you could just try that, brokercheck.com, and just put that up for a moment while I'm talking. Yeah, it's like an information warehouse of sorts, wholesaler for the industry. Not everything hits broker check that's in the CRD, but most meaningful information, undisclosed tax liens, a customer complaint over a certain dollar amount that's not resolved. Obviously, any state regulator enforcement action against the individual has to be reported on, I think it's a U6. It comes in, so, you know, if you had a problem with Massachusetts, if you had a problem with FINRA, if you had a customer complaint that was resolved for a certain amount, it's available to the public, anybody. And another wrinkle on this is, and Jeff will know about this, is when a rep wants to move and bring a book of business to another firm, sometimes the prior firm, the folks who are not happy at that person leaving, will say to customers who are considering moving with their longtime representative, you should check out broker check. And they'll use it as an effort to tar the individual and to motivate customers to stay at the firm that he just left. So it has massive multi-directional implications for representative, for firms too. You have a bunch of individuals at a branch office for a firm who have a record. The regulator is going to know about that, may start looking at that, may wonder why you have so many people under heightened supervision. In this context, yeah, it can be used for sure in the litigation of the liability phase. It comes in, and so.
Yeah, and FINRA's made it tougher the last couple of years to get an expungement, and they're trying to crack down on it. They've put certain new regulations in place. You know, they're making it more expensive. They're increasing the amount of arbitrators. It's a more onerous task than it used to be, because you're having these financial advisors trying to clean up their record. Some of it rightfully so.
Yeah, I'll give you an example, Michael. I handled a case last year where a customer made an absolutely false allegation against a broker. The broker-dealer investigated it, found it to be categorically false, and denied it. They were still required to report it on the CRD. They did. The broker brought an expungement action in FINRA dispute resolution to expunge it. And the broker-dealer agreed with the broker, didn't contest, did what they could, actually, even though it was a former employee at this point, to support the broker's claim while not spending much money. And FINRA denied expungement.
Did the arbitration panel request or require that the customer who lodged the complaint receive notice of the expungement request?
Yes.
And did the customer appear?
They did not. No, the customer didn't show up. I don't know I think it was the case. The broker waited until the customer had died in the case I handled, and that was probably, you know, the adverse inference flowing from that is probably what led the panel to not expunge.
Rob, I think we got a little off track, but I think it was worth it. So.
Yeah, no, and frankly, I was looking at broker check earlier today, and the way, if there is a complaint, and sometimes before it's substantiated, the way it shows up on your broker check is this like red dot. And it makes you wonder, it's just making a red flag, right? Like, so if you're dealing with this person, if you're an investor and you go there, you see all these red dots. And frankly, even for Brendan, his termination is there, right? The U5 that triggered his termination for the liens, that is still there. That will always be there, even though I got the remand from the bar. Obviously, that doesn't show up anymore. But yeah, some of these, some of the items listed on broker check, I understand why they're there, to protect the investing public. On the other hand, they can be really devastating to various brokers or members, and it's very difficult to recover from. So I did try to negotiate this with FINRA. We did have quite a bit of back and forth. From my conversations, and Michael, this goes to what you said earlier about oftentimes it matters who you're dealing with. The only contact I had was the individual who had originally requested the 8210 information from Brendan, and it was an investigator out of New York City. And frankly, they were good to deal with. They heard me out. I sent them information, and they said, essentially, let me run it up the flagpole, and you'll hear back from me. Now, I got the sense, reading between the lines from the investigator I was dealing with, that they may have been inclined to reopen this for me, and have me send in the medical information and maybe have an OTR and just document what happened with Brendan, because I offered that. But then I heard a couple of weeks later, no, the decision's final. We're standing by the bar. He did not exhaust his administrative remedies. And frankly, we sort of expected that to happen, because if you look at the cases, that's the lion's share of them, is even when you then appeal to the SEC, they will, as we say here, they apply the doctrine of administrative exhaustion, and they just decline to review the matter. You had an ability to do it with FINRA. You didn't take that opportunity, and now you're banned for life. We can go to the next slide now. So we had some hard conversations with Brendan, and we decided, you know what, we're going to appeal this to the SEC. And what we decided to go, obviously two prongs here, and a lot of it was based on what we saw in the Destina Mantar case, which is somewhat similar to Brendan's, but not completely, was lack of notice. And we felt like we had a pretty good claim in the lack of notice. A lot of the lack of notice cases you see are people saying, I never got the mail. I knew nothing about the 8210. I knew nothing about the 9552. For Brendan, we couldn't say that, because he did reach out to FINRA. He did get the mailing in the beginning, not the certified mail, but he clearly knew of the 8210 request because he reached out and had communications with them. And there was a back and forth, but then he just totally drops off the face of the earth, which is not consistent with how he had been interacting with them. And during that time period, after he stops communication, FINRA is sending him, as they're known to do, a lot of mailings, certified mailings, regular mail, and there's no proof at all he ever got any of the mailings. However, we did have one wrinkle. There was, I believe, one of the 9552 certified return receipt pieces of mail that did come back with a signature. But by that point, I had Brendan's signature on plenty of items. We looked at the signature, Nixon Peabody, and we said, this does not appear to be remotely similar to Brendan's signature. And we showed it to him. He said, I didn't sign that. That's not my signature. There was nobody authorized at his address in Newbury Street in Boston to accept mail. So luckily, we were able to overcome that. Obviously, we had to supply affidavits, which we were doing anyway for the medical information. And then the other prong we had, coupled with the lack of notice, that FINRA could not prove that he had notice of the remaining 8210 or the 9552, was extraordinary circumstances. And we felt like that was a strong argument because, obviously we had medical records. We would have had testimony from family members, from Brendan, that he had a very, very serious medical condition, required surgery. He, according to professionals, almost lost his life, and then had a very long period of rehabilitation. So we felt like those were the strongest arguments for us, but FINRA didn't roll over. They replied guns blazing to our memo. I think they filed a 28-pager, which threw the whole book at us. Basically, you didn't exhaust your remedies. You did have notice because there were some conversations, and then you, frankly, at that point, you should maybe either hired a lawyer or shouldn't have disappeared from the face of the earth. I thought maybe they were about ahead of their skis when they said, at one point, basically Brendan just totally ignored FINRA. Well, he did ignore FINRA, but he was in the hospital. Okay, so that's different than what you see in a lot of the other cases. In fact, the Mantar case, which we relied upon, and then the SEC relied upon, was it was a bit similar. She really didn't have the extraordinary circumstances. That was a rep who had worked for Goldman Sachs, was terminated, and they sent a lot. They sent obviously the 8210 request and the 9552, and she just didn't respond to anything until I think a day or two after her bar went into effect, and then responded saying, essentially, I'd never checked my mail. Of course, that was an actual notice case too, because FINRA didn't have the ability to say, no, here's your signature, or here's an email from you. You did in fact have actual notice. But what we really tried to push was the totality of the circumstances which came out of Mantar, and the totality being, one, FINRA can't prove that we had actual notice, and these circumstances are clearly not the case, which you may see, and FINRA is rightfully concerned about, where you have brokers who are just totally ignoring FINRA because they know they have another matter out there that brings more jeopardy, and maybe one day they'll circle back and deal with FINRA, but they're not going to do it right now. So we have up on the screen here SEC's their key conclusion, which they put up, which they relied upon to remand this back to FINRA. And again, I think it was because we put so much weight on the actual notice, but that wasn't, originally when we were, debating, how strong of a case this was. There was the issue clearly of somebody had signed this certification that the mail had been delivered. But again, because it was so outlandish that it looked nothing like Brendan's signature, I think we were able to overcome that. But I think this, frankly, was a closer call than Mantar in that respect, because FINRA didn't have that there. But what we had in our favor was the fact that he had been hospitalized, and we could document the reason why he was just not physically able to respond.
Rob, how long did the process take from the bar to getting to the SEC and a decision from the SEC?
So that brings up another point, which Brendan was barred, I believe, looking at my notes, in November of 2018. He reached out to me at Nixon Peabody in, I believe it was maybe late February, early March, when he retained us. But we didn't reach out to FINRA until April. Now, according to their documents, they say our official communication with them was in early May, but I had been emailing the investigator, but of course and again, I'll get to this in the conclusions, but I think it's important to note here, as an attorney representing somebody who is essentially a target of FINRA, either with the 8210 or a 9552 or some other rule, you have to realize that you're always on the record too. And I think that's a little different sometimes than what you're dealing with DOJ or the Attorney General's office. Oftentimes when I have clients with the Department of Justice, I'll reach out to the prosecutor, and my communications or the timing of my communications are almost never relevant to anything that will ever be filed in federal court. You have to be cognizant here, though, that all your communications with FINRA are going to be put in a timeline and passed up to the SEC. And of course, mine were. And they tried to use that against us, that there was this like 5-month delay from the November or December bar. And then when we officially reach out to FINRA in April or May of 2019. So we had that to overcome. But frankly, the SEC didn't put a lot of weight in that delay, because Brendan he was attempting to do the right thing, hired an attorney, the attorney reached out. Obviously, you have to have some amount of time with your client before you can just reach out to FINRA, and for good reason, because you have to understand they're documenting all of that entire procedural history, whether it's emails, phone calls, letters, and of course, if you read the documents, they outlined that for the SEC when I reached out. So then we appealed in, I think, June or July of 2019. And then we didn't get a decision back. It was about a year. I think it was about a year with all the briefing schedules. There were obviously some delays then because of COVID. And of course, once you have an appeal pending with the SEC, they can extend their deadlines, as often if they like. But we were very relieved when we got the decision, obviously, that it was going to be remanded to FINRA. Of course, at that point, then you buckle up and you think, okay, it's been remanded, but you're not out of the woods yet. Frankly, at that point, they could see, okay, we reviewed the documentation you supplied with the 8210 information, but we want to have an OTR and maybe discuss some other type of settlement. But they didn't do that. They essentially dropped it. So it was an all-around good result for Brendan.
So let's rewind. What do you believe is the best practices here on how to tackle this if we're faced with this in the future? What lessons do we learn from this?
Well, actually, we can go to the next slide, which are 2 ways to read the opinion, and that I think will help frame this argument. So, I know Jeff, in the Lawyer's Weekly article, you commented, and Will, and I think this is now the time everybody can jump in on how they think this opinion will be viewed going forward, of course, with Mantar. The narrow view is this isn't a very fact-specific case, right? You have an individual who did have a serious medical emergency, and that was the reason he sort of dropped off the map. And then you couple that with the issue FINRA had with no proof of actual notice that could be substantiated. So if you read it narrowly, it's a one-off, and you have to fit these very narrow, I think, exceptions within the case. The broader view is if the SEC will sort of look away from the extraordinary circumstances and the totality of the circumstances and put more weight on the actual notice. And that could make things a bit more difficult for FINRA if you do have somebody who is a bad actor and is ignoring FINRA by design because of some other issue that's causing them jeopardy, and they just don't open their mail, don't sign for things, and have some other convenient excuse like, yeah, I moved, but I never updated my CRD, right? That could be a bit more tenuous. And I'm not, frankly, if I had a bet now, I wonder if the narrow view is gonna carry more weight going forward, but I'd be happy to hear from you folks as to what you think will happen going forward. And if this does mean there's a crack in the dam and more people will potentially be able to get their bar remanded after they ignore FINRA.
Jeff, we'll start with you.
Yeah, I don't have your insight, Rob, into FINRA and the way it thinks, but I tend towards the broader view. My first thought on reading this opinion and then reading your briefs and really thinking about the case is that the SEC or what could have been trying to send a message to FINRA that this draconian approach that you talked about earlier of outright bar if they don't get responses to the 8210s. Is not appropriate in all circumstances, and I'm hopeful, I guess, that the SEC was trying to either send the message or FINRA will understand that just because it's administratively more convenient for them to issue an outright ban if they don't get responses to the 8210s, and just because they really feel strongly about sending a message to the members that the 8210s are serious business and they have to pay attention to them, isn't enough of a ground to work even one injustice in a case like this, where you've got a guy who clearly didn't deserve a lifetime ban, and clearly was not getting notice, had very good excuses, and the underlying offense was not at all serious, right? This is a guy who at worst failed to report tax liens. There's no customer misconduct. So I tend towards the broader view, and I'm hopeful that this decision, which was fantastic to see, And I'd be remiss if I didn't say I was also really impressed with the work you did on this case. I know I've told you that before. And you know, not a lot of brokers have the access and the wherewithal to get to work with lawyers of your caliber. So it was good to see a broker in this case standing up, fighting, getting a good result, and hopefully moving FINRA farther away from the extreme where it's historically been, and towards a more reasoned and nuanced approach to 8210 defaults.
Will?
Yeah, I'll make 2 points. Judging by the numbers of ways and the redundancies and the notices I've been getting from FINRA, everything's duplicate in the mail, not on this kind of proceeding, just generally speaking. I think they're taking the actual notice message from the SEC very seriously. And I don't know if this is the trigger, but I seem to be getting more of the same mail in the same case than I've ever gotten before. And I don't know if that's just idiosyncratic to my case or not, but I think the overall message from the SEC is that this is not the guy that this was intended for. So it's maybe a totality of the circumstances in that sense. He did have the extraordinary circumstances of his illness. He tried to do the right thing. You didn't really give him a chance upon consultation with his lawyer to sort of work this out. And if the rule is intended, it's really intended for folks who are bad actors and who are ignoring the proceedings and undermining the deterrent ability of FINRA to get members and registered reps to comply with information requests. I mean, that's ultimately the point of 8210. So while I certainly didn't say that as much, I think the message is think more deeply before you exercise this vast power, particularly where there are circumstances that just common sense justice would say this is not the guy. I'm reading into it, but that's my take on it.
Yeah, well, I think I agree with both of you with respect to this. I take the broader view as well. I think that FINRA, if they're going to exercise this power, they have to do a little bit more groundwork and look into the person a little bit more and find a different way of reaching out to this person. Clearly, if it was by mail and it was return receipt requested and it kept getting returned, there's a reason for that. So they could have exercised a little bit more patience and could have found other ways of inquiring about this particular financial advisor's whereabouts and not bring down the hammer. I feel that I've come across the threat of a bar seems to be prevalent with FINRA, and they use it as a carrot and stick more often than not. And I think that this person, obviously, there are bigger fish to fry out there, and this wasn't the person that the rule was intended for. So, I think there's patience and better practice and ways to give better notice than they did in this case. So, Rob, do you have any closing thoughts before we wrap this up?
If we could just flip to the last slide, that'd be great. And Jeff, thank you for the compliment. And of course, I'm gonna another shout out to my associate Scott Seitz, who did great work with the writing and the drafting and the research. But and you raised a good point, Jeff. I think this may have been a different outcome if there was some allegation of fraud or a client was a victim and there really was some other overarching issue. But again, it was a tax lien, and not for nothing, he did report one of them. So it's not like hiding one tax lien over another gets you any leverage with your employer. Actually, this is the second to last. If we can just flip to the last slide. So a couple of takeaways, obviously, for FINRA members, you don't want to ignore 8210 or 9552. Like we said earlier, if you do have a Rule 8210 request, always a good idea to consult with an attorney, because you don't want to be essentially under oath with an enforcement attorney who, having worked at FINRA, the enforcement attorneys in most of the offices across the country, former big firm lawyers. They're very well polished. They have a lot of resources. They will do a very good job on getting the information they need. So you really have to be able to defend yourself, I think, at an early stage. And a word of advice to lawyers who do this work, if you don't already know, like I said, make sure you are prepared before dealing with FINRA, because that was something that a couple of nights of not great sleep, wondering when to pull the trigger on going forward with Brendan. Because you have to, you can't wait forever till I get every piece of documentation he has and every medical record from every provider, because at some point you just have to engage with FINRA. But knowing exactly when to do that is a fine balance, because like I said, they keep a record of everything, and you're going to be reading about what you did and didn't do when there's an appeal to the SEC.
Okay, well, I thank my fellow panelists, Jeff Millsom, Will Haddad, and Rob Fisher. And this concludes our webinar for today. Thank you.
Thank you.
All right, thanks.
Thank you, all of you. And we look forward to having all of you again on another panel in the future. Have a great day.
Thank you. You too.
Thank you. Take care.